right, well, we've got a great panel here, in-house panel, largely, with one
ex-in-house.
Ex-in-house, so he'll channel the in-house experience. But
Yep.
starting my far left, Avi Schwartz, in-house counsel, IP counsel at Edwards Life Science, who's had a lot of experience in the UPC. And Mark Schildkraut from Stanley Black & Decker, also chief IP counsel. And Ari Laakkonen at the Powell Gilbert firm, who will channel his own experience. And he was also formerly at Nokia, is that right?
Yep, that's right.
So I wanted to start off and just basically get your experiences. So let's start with Avi. I guess a day one litigant in the UPC. Is that right, Avi?
That's right. So we've had quite a bit of experience at the UPC as a patent owner. So we're coming at it from the patent owner perspective. We haven't been, an accused infringer, at least not yet at the UPC. So we're coming at it from that perspective. And we were there on day one because actually we had some pre-existing litigation going on with a competitor. And we had filed some of those cases in some national courts. And then when the UPC came online, we thought this was a good opportunity to basically cover more countries, and so we were there on day one.
Yeah, Mark?
Yeah, and I bring a different perspective in that I was in medical devices for 18 years at a company called Becton Dickinson, but a few years ago I moved to a consumer products company, and I was first at Shark Ninja, Shark vacuums, Ninja kitchen appliances, and we were involved in a UPC case a couple of years ago. And that's when the court was only about a year old, so at least there was a year of experience, more than a day. And then at Stanley Black & Decker, when I first joined about a year ago, we were also involved as a defendant in a case in the Nordic Division. So I have some experience from the defense side that I want to share as well.
Ari, how about yourself?
Well, I think the thing that strikes me most actually is how the predictions of the failure of the UPC didn't come to pass. Because 2, maybe 3 years ago, we all thought that the sky was going to fall on our heads when the UPC system would come in. There was a whole transitional period set up. And people were wondering, should we opt out patents? Should we litigate in the national system? And how is this new system going to work? By and large, not only has it worked, but it's really, what it's done is it's established a new category or species of law. It's established a new doctrine of European patent law with its own jurisdictional rules, its own substantive legal rules. And this doctrine is now being developed where the intellectual giants that have done the work there are the Court of Appeal, who have really pushed this new approach. It's separated, it's sort of untethered now from its national law origins, and it's started to make progress on its own. And so that's the main, I think, the overriding impression that I've got is that it's suddenly, without anyone noticing, the system has worked, and we're now living with it, and we're debating about statistics, but ultimately, at the end of the day, it's a workable system.
So Avi, as a day one litigant and a user of the system throughout the whole time here, what's been the big challenge from an in-house perspective as you've got your in-house obligations? What's been the challenge, the surprise that you've had to deal with in this new system?
So I guess maybe a little bit more background for our company. I guess also I'll preface this by saying that these are my personal views, not the views of my company. So we're in the medical device space, right? Med tech. Our company, by and large, is selling heart valves. And so I guess, some of the surprises or some of the things that you've already might have heard about, right? Some of the things like, for example, being able to amend patent claims as part of the process, right? That's something that maybe is a surprise. But one thing that was a bit of a surprise that I think is worth sharing that hasn't really come up so much yet in the discussion so far is, we obviously heard mention of the bifurcated system, famously in Germany, right? You have one court for determining infringement and another court for determining the validity of a patent. And the UPC was originally, set up to be a non-bifurcated system, right? By and large, there was maybe a few exceptions, but it was set up to have one court deciding infringement and validity. And so that was to avoid some of the issues that have already been mentioned with regard to the German bifurcated system. We've heard about the injunction gap, right? Potentially the validity court, if it's as it is in Germany, goes much more slowly than the infringement court. So you might end up in a situation as a defendant in Germany where you're facing the prospect of an injunction, a year or more before you end up getting your decision on potentially the invalidity of the patent. And so the UPC wasn't really supposed to be bifurcated, but our experience there has been that it's actually possible for a defendant to kind of force a validity action in one of the other divisions of the UPC. So, for example, we filed a case in the Munich local division against this defendant, and a fully owned subsidiary, fully controlled by the defendant, actually filed a standalone revocation action in the Paris Central division. And what ended up happening is actually, we basically said, hey, this should have been brought in the Munich local division, and the Paris Central division actually decided, no, this is actually okay. They could actually do this. And so we first basically had to fight about validity in the Paris Central division before getting a chance to have our fight in the Munich local division about infringement. And so that's something that obviously, patent owners should be aware of, this possibility, right, and prepare for that. But also, if you're, an accused infringer, defendant, that's something also that you should also be thinking about, right? Would you rather potentially have validity of the patent decided first in one of the central divisions rather than in one of the local divisions where you might have been
That only
sued?
happened because it was a subsidiary, or because everybody has subsidiaries, so they
Yeah, honestly, it seems like you could just create a new subsidiary, right, and do this, right? So essentially, the court is viewing this in a very kind of formal way, whereas here in the United States, for example, when you're dealing with, let's say, the PTAB, right, there's this concept of real parties in interest, right, and they don't have that same sort of concept, at least not yet, until the Court of Appeals of the UPC decides otherwise. This is kind of the current law of the land, and I don't think, my prediction is, I don't think the Court of Appeal is really going to change that very, very much, and so that will still be an option for defendants in the UPC.
10 years ago in Germany, in validity court, they had a lot of straw man issues. Did you file a revocation claim with straw man?
Let me repeat the question to get it on the record. So in Germany, you had a lot of straw man issues. We used to previously in the old system, and now the question is, how does this straw man action work? Is there a real party interest concept here in the UPC?
So that's a good question. I don't know, right? And maybe one of the European attorneys here can address the straw man issue, but we haven't had to deal with that straw man issue. In my
You
experience.
see the straw man a lot in oppositions at the EPO,
Right.
but yeah, whether it happens at the UPC or not, I'm not sure. It sounds like we have somebody here that has some information.
Luckily, we have an expert.
Yeah.
I think that the reason why the strawman litigation stopped in Germany was because the court fees became higher. You need to find a strawman who is willing to do something like this. But if it's, for instance, a telecommunication case where the litigation value can easily go up to 30 million, nobody will be willing. You will not find a professor from the university to do something like that. And I think the main reason was that the costs are so extremely different to what you have at the EPO. At the EPO, it's still possible to file strawman actions because you have not the risk to be, faced then with a reimbursement claim. And I think that's the main reason why it doesn't happen. Because it should happen with the Federal Patent Court, because the Federal Patent Court in Munich is amazingly really patentee unfriendly compared to the EPO, which you can say that this is more a patentee friendly forum.
All right, well, let's move on. Mark, what have been your surprises?
Yeah, I'd say there are probably two challenges that I want to talk about that I think the first one, both parties, whether you're a claimant or a defendant, would face, and that is the unpredictability by virtue of having a new court. Even though it is, yes, I would agree with Ari, it is seemingly working out, and you could tell that it's here to stay. But right now, the laws, substantive laws, the process, the procedural laws are still developing. And when you're representing a company, which we all do, whether you're in house or outside, companies want predictability, and it's hard to get predictability with a new court. Cases are starting to go to appeals. I think we're going to see that smooth out over the course of the next few years. So the good news is it's here to stay. The challenge that I think both claimants and defendants would have is that unpredictability. And then from a defense standpoint, I think a unique aspect is the speed, right? I mean, a plaintiff or a claimant often has time to prepare their case. Not always. They may want to act very quickly because they may want to seek a preliminary injunction. But the defense has a very, very short window to put together their defense if they're not ready for it. So my counsel to say potential defendant, if you're getting a cease and desist letter, or you just maybe know that you have a competitor that maybe you're close to their space, is really think ahead. Maybe you want to file what's called a protective letter. We'll get to that later, I think, which is a document you can file with the court so that if there is a request for a preliminary injunction, your defense is already well baked and it's actually accessible to the court. It's kept confidential until that PI motion the preliminary injunction motion surfaces. And then the other thing I would say is, consider bringing, if you're a defendant, consider bringing a revocation action where you've heard you can actually, and we'll talk about this later, I believe as well, but you could actually make a first strike as a defendant. And by doing that, you can be more prepared and be on the offense at first. Of course, it's going to flip in terms of the posture that you're in, but at least you're ahead of the game in terms of some of the analyses and defenses that you want to proffer.
I want to seize on that last point. So, we've been hearing all day that it's such a patentee-friendly jurisdiction, and the plaintiffs are winning at quite a high rate. So is this creating an incentive now for you to take the offense and take a preemptive strike and go to the central division when it's basically their version of the PTAB, and to try to file one of these standalone revocation actions to go on the offense? Is that the playbook now?
It's a tough decision. I mean, I'm not sure what the statistics are just yet, but I know for a company that feels that they might be in litigation, it's a tough decision because if you bring it, you're pretty much now forcing a litigation. But if you get that cease and desist letter and you feel it's pretty much just a matter of time before you are going to be the defendant in a case, I think it's something that you should consider. It also allows you to choose the jurisdiction that you think might be more favorable.
Or maybe you could cook up a new subsidiary in Slovenia and file through that one, which apparently, Avi, right, is a workable strategy.
Yeah, that's right. And so, I mean, of course, to Mark's point, right, if you do kind of launch this first strike revocation action, then you're basically forcing, right, the countersuit for infringement, right, and so that is a risk. But if you think you're going to be getting that lawsuit anyway, right, then maybe it is an option, and you'd prefer to be in the central division as opposed to the Munich local division, which is a popular place, obviously, for patent owner plaintiffs to file.
So Steve,
please.
to put that in U.S. lawyer language, this is the equivalent of a declaratory judgment action here in the U.S. Just with some corporate shenanigans.
I mean, the technical distinction is you're not bringing a declaratory judgment for non-infringement, but you're right. From a posture standpoint, you're getting to choose a jurisdiction. You're getting ahead of it. I would agree.
Do you need standing? Can anybody do it, or do you have to be threatened with a C&D letter or something like that?
I don't know why you would bring it there if you weren't being threatened or felt an apprehension of harm. I'm not sure what the standard is. I can tell you the times that we consider it is if we feel that there's a real apprehension of harm. So I say it comes close to the DJ standard, but technically there might be somebody here that knows from Europe whether you actually have to be threatened to do that. I don't think you do. Okay. Well, we're hearing you don't.
How did the parallel proceedings play out? The transfer of the case from the infringement timeline?
Well, so that goes.
You repeat the question.
Yeah. So the question is, how do those play out? We're talking about revocation, invalidating the patent. We're talking about infringement. So, and you've already heard Avi say that by bringing the revocation action, you're pretty much now necessitating, you're causing an infringement action to now surface. Maybe it was happening anyway, but now you're definitely doing that because no one's going to want to just take punches and not hit back. And I think a lot of it will come down to it'll follow the same rules in general. But I think a big question then becomes to what was mentioned before, whether those two issues, invalidity and non-infringement, are going to be bifurcated or not. And again, that is we're still in the section where we're talking about surprises. I think the fact that there still is a lot of uncertainty about whether those two issues are being bifurcated or not, that's something that's not consistent across the board.
Yeah, and in my case, right, it didn't really work out for the defendant, right? In our particular case, right? So we filed in the Munich local division, we filed an infringement action. Then the other side, basically went to the Paris central division and filed the revocation action there. And so what ended up happening basically is the Munich local division basically decided to wait for the Paris central division to rule on validity first. So it delayed our case a little bit in Munich, but ultimately the Paris central division decided that we had a valid patent, right? And so then what ended up happening is then basically we ended up then prevailing also in the Munich local division on infringement and validity. So basically the Munich local division also had to basically kind of take a second look at validity. And so it ended up, to a certain extent, in this particular case, backfiring a little bit, because then we basically had a super valid patent that was infringed, right? And so it was helpful in that sense, but it did slow things down. And obviously they did get a shot at potentially knocking out everything first, right, by getting a ruling in the Paris Central Division for invalidity. So it didn't work out for them in this instance, but that doesn't mean that it always won't work out, right? Obviously, you only want to do this, I think, if you feel like you have a pretty good invalidity case, right? If you're an accused infringer, right? If it's a pretty weak invalidity case, it probably doesn't make a whole lot of sense to do that, because it definitely did also, by the way, annoy the judges in the Munich local division, right? So, sure.
But I think another reason, and I see there's a question, but I think another reason to think about whether you bifurcate or not, if you're a defendant, having them together, both invalidity and infringement, you can cause a squeeze play, right? I mean, if a plaintiff tries to make the patent too broad to win on an infringement, then they are running the risk, of course, that the patent will be invalidated. So if you have the same tribunal and you're having those two issues argued at the same time, I think that could be really good for a defendant as well at times.
I have just one question for Avi. Have the cases been combined at the appeal stage then? Or has the case been settled before, probably?
So no, it's actually still going on, right,
Yeah.
at the appeal stage. And yes, basically the Court of Appeal decided to hear everything all together.
Okay.
in one case. Technically, they're separate cases, right, but they decided to have one hearing to address all of the issues.
Thank you. Did the Munich panel and the Paris panel share common judges? Because sometimes I know the UPC that's what they are doing. They are putting the same judges, like the third legally qualified judges and the technical judges. They're going to pick the same to be sure that there is some kind of uniformity between these two decisions.
Yeah, so the technically qualified judge was the same for both, right? So the technically qualified judge so I guess let's back up. I mean, I think people sort of mentioned this, but basically most of the panels are comprised of legally qualified judges and technically qualified judges, right? And so, so the technically qualified judge was the same in both the Munich local division and in the Paris central division, but the legally qualified judges were completely different. There was no overlap in the legally qualified judges.
Right. Well, let's talk about the different local divisions. You've got, obviously, people file in Munich a lot. In Germany, there's 4 divisions there, but you've also got the Baltics, you've got Lisbon, you've got Helsinki, you've got all these places. How do you, from an in-house perspective, perceive this? And Avi, you were on the offense. Why'd you go to Munich? And what would you consider about the other jurisdictions?
So, what I would say is we didn't just actually go to Munich in the first instance, right? So when we filed several actions on the first day, we actually filed some in the Munich local division, and we filed some in the Nordic Baltic division as well. So I have experience now in the Nordic Baltic division, the Munich local division, and obviously now the Paris Central division as well. And so just some quick high level thoughts. I mean, at the beginning there was some uncertainty, like we were saying, about how the different divisions would be handling things. And so that was one of the reasons why we decided to basically go for both the Munich local division and the Nordic Baltic division. I think now, based on the experience, some of the things that people have mentioned about the Munich local division are things that I would echo, right? There's a lot of certainty, I think, on timing that you get. With the Munich local division, things are pretty certain as far as how long things are going to take. It moves generally pretty quickly. I will also say, based on my experience, the Munich local division has some other things that are helpful and nice that you don't get in all the other divisions, which is, for example, when you're actually going to have the actual hearing, the day of the trial, they generally give you an introduction. And the introduction is almost like a preliminary opinion. They kind of tell you what they're thinking, where they are, what are some of the questions they have, and they really guide the discussions. I'll say, in contrast, the Paris Central Division has, in my experience, I've been there now a couple of times, has not given the same sort of introduction where they give some of their thoughts as far as a preliminary opinion and guide the parties. The Paris Central Division generally just lets the parties present their case without providing a whole lot of guidance. Also, the Munich local division had a lot of questions from the judges. The Paris Central Division maybe a little bit less so as well. And then I'll say for the Nordic Baltic division, in my experience, they also did provide an introduction and give some guidance to the parties on the day of the hearing. But I will say one of the key differences, at least so far, has been that the Nordic Baltic division has been pretty slow, right? And so, for example, issuing decisions, right? It's been taking a very long time. And also, they don't, like Munich actually will give you a date certain as to when they're actually going to issue their written opinion after the hearing, right? And so you know exactly when you're going to be getting the decision from the court. Whereas the Nordic Baltic Division and the Paris Central Division do not do that, right? They don't give you a date where you know you're actually going to be getting the decision. So there's kind of a target, right? The court is targeting in general, I think, about 6 weeks or so after the date of the hearing to actually issue their kind of determination. But that doesn't always work out in practice, right? Depending on how busy the court is and other factors. And so in my experience, the Nordic Baltic division, for example, has been much slower than that 6 week sort of ideal time frame.
Ari, you had some time in Lisbon, I understand. How did that go?
Lisbon was fantastic. Someone mentioned food earlier, and I, sort of think that was probably, sort of underneath it all, a sort of a big reason. But in fact, it was the opponent, our opponent at the time in that particular case, which was Ericsson, who chose Lisbon. And I think it sort of illustrates that probably the big reason for choosing the venue is the strategy of the case. Because that's been we used to have for pan-European litigation, strategy was a big component, and now it's gone up probably to the next level, and now it's an increasingly important part of the puzzle. There's a number of reasons why strategy is important, and that one of them is the jurisdictional framework of the UPC. There's only a certain number of ways, literally under the UPC agreement, in which you can start a case. For example, you have an infringement claim. And then later on, someone could have a license defense to that, and it would be contractual in nature. And you'd need to determine whether there's, what the contractual position is. But under the UPC agreements, it's unclear whether you can actually start with a contractual issue, or do you need to start with a patent law issue? I think you probably need to start with a patent law issue to be safe. And so the maneuvering that people are doing to try and understand where do they start, what kind of claim do they start with, and in which forum do they start, is key. And the BSH and its long arm logic is part of that. In order to get jurisdiction there, you need to start in the domicile of the defendant. And then that'll take you, it might take you to Lisbon, or it might take you to the Nordic Baltic division if you're going after one of the Nordics. And so, but, you know, to answer your question, and I'm sorry about the diversion, but to answer your question properly, Lisbon was the actual hearing, which was a PI hearing, involved the Portuguese judge who was presiding, a judge from Belgium, and a judge from Finland, all in the same hearing. So you got a multinational judge panel, and I think an Austrian technical judge addressing the issues. Yes, it was physically in Lisbon, but it was actually a European hearing. And it had the same quality that you would expect of every single UPC court. And so it was a perfectly, you know, sort of satisfactory and sort of experience. And that's one of the joys of the new system, is that it does allow litigation to be conducted in different forums.
Mark, you've been primarily on the defense there. How do you perceive the different jurisdictions you might get pulled into?
Yes, when you're on the defensive side, I think there's a couple things. We talked about the speed, so we try to oftentimes, if you're not as prepared as the plaintiff at the outset, you want you would prefer things to go slower than faster. So I know, again, we hear that in some of the German jurisdictions, things tend to move much more quickly than. Not much more, but at least more quickly than say in the Nordic region. And sometimes as a defendant, because you never know how the case is going to go, you might be working on a design around. So time is your friend when you're a defendant. So if you could choose a jurisdiction, and how do you choose it? Really, if you want to bring a revocation, but if you have that opportunity to choose it, then that's one thing that you'd want to look at. If you think you have a very strong case, there is some benefit of going to the central division versus, say, the local division, and that is you will get a technically qualified judge on your panel if you go to the central division, and you don't necessarily have that at the local division. So I think those are a couple of things that you'd be thinking about. But again, as a defendant, you're often much less in the position of choosing the jurisdiction that you're in.
Right. Let's talk about preliminary. Oh, we got a question.
One question. I understand, why you would choose the UPC now compared to the U.S. Even within the UPC,
one thing I still don't understand, though. One thing I still don't understand, though, is why. Let's say if you're on the patentee side, and to take your example, if you're in Lisbon, or if you have a European patent and you've validated it in Portugal, you're concerned about infringement happening in Portugal. Why would a patentee choose the UPC to litigate this instead of just the national court of, you can place it with any country, Sweden or even Germany or France?
Well, one answer to that question is, if you look at the average duration of an infringement case in those countries pre-UPC, I think in Spain, it was quite long. And the simple answer, I think, Spain, of course, has to be targeted with a long arm action. That's true. But, you could look at contracting member states, and there will be contracting member states where patent litigation will take several years, maybe even 5 or 6 years, which made litigation economically and sort of commercially impractical. And the UPC will get you there in a year, roughly. So I think it's speed. Plus you get an international judge panel. That was, I think, installed to recognize the fact that in countries with less patent litigation experience, it's inevitable that the judges are going to be less experienced than in countries with a lot of patent litigation. And so by putting in a multinational panel, you kind of spread the experience and you make sure that you improve the quality of the output at the same time as making it faster. And of course, then there's the geographic scope of the injunction, because even though it may be that there's infringement right now in Lisbon, to prevent infringement in the future in other states, then you want your injunction to be comprehensive and to cover all of the possible, locations where it's granted.
Just a question for you. I mean, just to get the concept out there, if invalidity is a concern to you as the patentee, then you might go more nationally than to the UPC because are you concerned that you might lose your patent in one stroke?
Sure. I mean, that I think is the life sciences side of the story, because, you know, having just invested something like 400 million in the development of a new blockbuster drug, you'd probably prefer not to risk it all with a throw of the dice on a one-day hearing somewhere centrally, because maybe you think that it's not worth it as a game. To be played. And so the insurance policy in that particular situation is to get national patent coverage. Now, of course, the reality may be that if you get a decision in an influential state, like, say, Germany, and the German patent office decides to revoke the patent, then it's debatable whether other courts would maintain the patent. But, you know, that's a fight for another day, and you live to fight another day. So there's a certain sort of, you know, you can choose trench warfare to protect the validity of the patent if you really want to. But the point is that the option is there, and people can sort of decide the level of comfort that they have with the new system. I think the ability to put in amendments to the claim helps a little bit, because it's difficult, you know, when you're at the patent prosecution stage, and I say this with never having filed a single patent application, so my firm doesn't do any prosecution. But, you know, at the patent prosecution stage, how are you supposed to be able to guess what issues come up during litigation a decade later? And so an amendment to the claim can be helpful in identifying bits of the invention that were critical and then inserting them later on into the claim.
All right. Let's talk about preliminary injunctions. We've been hearing that they grant them at a very high rate in Europe, as opposed to the U.S., where it's Bigfoot. You hear about them, but you really don't see them. From the in-house perspective, either on the offense or defense, what do you see? I mean, is this terrifying for you, and how do you deal with it?
Well, if you're going to use the word terrifying, I'll take it from the defendant side, of course. Yeah, that is something that business folks do not want to see in a company, of course. So that is something that does terrify us if we think that could happen. But there is something you can do to help protect yourself from that. I mentioned this at the outset. There's a vehicle called having a protective letter filed with the court. And so if you are up against an aggressive, say, plaintiff, and you think you have a basis for non-infringement and or invalidity, and therefore you want to commercialize the technology, there is something that you can do. And before I go on, I mean, the one risk is, at least in the German courts, maybe at the UPC as well, you can get what's called an ex parte decision of an injunction, and that's something that really, would upset a defendant. So a protective letter is basically a letter or a document that you can file with the court. It's confidential, so nobody except for the court knows that it's being filed, and it has some or many of your defenses laid out. You don't want it so laid out in such particularity that the court feels like, hey, we don't even need to hear from the defendant because the arguments are all there. So it really is an art and a science, and it's something that, or maybe more of an art than a science. That's something you want to make sure you're working with really, really seasoned European counsel to put together. But if any of your in-house or outside clients are facing that risk, it's something that you want to make sure that you have registered with the court. And then what happens is if there is, say, a plaintiff that brings a lawsuit and moves for a preliminary injunction, and they do that and the defendant doesn't even know about it, the letter can come out and the court would know that there are defenses, and they'll at least entertain that. And they might, more likely than not, hopefully would bring in the defendant so that they can defend themselves and not face a preliminary injunction unless it's meritorious.
And I'll just add, it obviously is a very powerful tool for a patent owner, a preliminary injunction, and the option to potentially seek a preliminary injunction. But one thing I will just say, which is kind of a little bit different, I think, than maybe a lot of U.S. attorneys think about when they think about preliminary injunctions, is this kind of strict urgency requirement that often comes up in Europe, right? And what that means is that, oftentimes you need to seek a preliminary injunction within a relatively short period of time, sometimes like 30 days, something like that, right? And if you don't do it within that kind of, if you don't act quickly enough and meet this urgency requirement, then really a preliminary injunction can be denied on that basis alone. And so that makes it a little bit challenging sometimes from a patent owner perspective to be able to, find out about the infringement and then act quickly enough to basically seek that preliminary injunction and meet that urgency requirement.
By a 30 days from discovery of the infringement?
Correct. Essentially, yes, that's right. When you become aware. Oh, the question was, when does the clock start ticking, right, for that urgency requirement? And that's right. It's basically when you become aware of it, is my understanding, right? So if you weren't aware of it and there had been some infringement out there, then obviously it wouldn't really be fair to kind of count that against you as far as the clock. But yes, once you find out about it, the clock starts ticking, and then you have to act very, very quickly to get everything on file if you want to seek a preliminary injunction.
But one other more terrifying aspect of the UPC is the provision, at least actually as in some countries, maybe not all, but these dawn rays, the saisie contrefaçon, where they will have a bailiff go on an ex parte basis and you'll storm the other side's facilities and grab stuff. I would love to do one of these. One of these days, maybe I will. It's on my bucket list. But, from the in-house perspective, with this out there being a possibility, like how do you deal with this?
Yeah, so I can comment on that. So, and this is something that's been quite common in France, even before the UPC and some other countries. But basically, yes, there is a capability for a plaintiff to apply for a seizure. They could do it, say, at your place of business. They could do it at a trade show, and basically that could be quite daunting as well. If again you have reason to believe that maybe you got a cease and desist letter, you have reason to believe that something like this can happen. And let's back up. Why is that? We hear that in most countries in Europe there is really no discovery, right? So this is more of an evidentiary preservation as well as some very limited discovery in a way that you could take advantage of. So if that is something as a plaintiff you could take advantage of, it could be very powerful. So what can you do as a defendant knowing that might happen to you? One thing is to know what is really the scope of what that seizure is, right? They don't come in and just take out all your computers and take out all your manufacturing capabilities, right? What do they take? They may be able to get some samples. They might be able to get some technical drawings. They might be able to get some financial documents to understand the exposure. So, I mean, it's not a carte blanche, license to just come in and take whatever you want. So what can you do as a defendant is you can be ready for it, maybe at a trade show or at your place of business. You can have really a box that has a few samples of maybe what the accused product is, have some technical drawings, have some financials ready. And then if the person that the receptionist, whoever it is that's at the office or whoever's personing the booth at a trade show, if a bailiff comes in and shows the appropriate documentation, you can be ready for it and you can make it actually much less disruptive than it could otherwise be.
Yeah.
Yes, thank you. Of course, I speak under the control of the French lawyers present because this has been an enduring aspect of the French system for decades, and it's one of those sort of little darlings of the French system that is survived and made its way into the UPC. The point I would make about it is that privilege is a key issue because obviously what you'd want to do is to stop privileged documents from being extracted if you're subjected to one of these raids. Under European law, because of course these kinds of dawn raids were available in competition law investigations, and under the Axo Nobel decision, privilege was only accorded to EU qualified lawyers. And it was their work product, which was exempt from seizure. And we're yet to see what the case law in the UPC is and whose work product exactly is going to be exempt and immune from it. But I think it would make sense, and it would probably be a very practical and measure to make sure that you do actually then make sure that where you do have sensitive material, you make sure that your EU lawyers are copied on that, and it comes under the into that sort of bracket of or category of protected work product that you don't want to be disclosing.
All right, we're just down a few minutes. Last topic here is money. It's about budgeting. This is not the U.S., not the massive, cases we have here, but still, it's a significant expense. So, Avi, what do you think about all this?
Yeah, so I mean, it compared to U.S. litigation, that's right. It is much less expensive compared to U.S. litigation. But because the cases move so quickly and there has to be so much work done up front, there is kind of a large upfront expense, right? Compared to, for example, U.S. litigation, which generally starts pretty slowly, right? As a patent owner plaintiff, you can usually get a complaint on file relatively easily and cheaply, right? And then kind of things can develop from there. Whereas in the UPC, if you're going to file, there's going to be a lot of work that needs to be done up front, and so you're looking at kind of some rather significant, upfront costs in order to actually get a case on file.
Right. Mark?
Yeah, we heard a lot today that the cases are less expensive, and of course they are. But you're right; it's all compressed in about a year, a little bit more than a year. So when you're working with your finance folks and you're telling them that it's relatively inexpensive, they don't see it that way. But it is. But it is all coming out in 1 year. But a lot of times these cases aren't happening in a vacuum at the UPC. There might be an opposition at the EPO. Far less expensive than a UPC case, but even that adds expense. And then sometimes you're fighting in other jurisdictions. You might be fighting in the U.S. as well. So, it from a defense standpoint, we start telling our business folks it's expensive, even though you hear it's less expensive relative to what the discovery that you see in the UK and the US.
Raj, you have a question?
So another aspect of the UPC versus the US is cost shifting. Of course, you're liable for the other side's costs if you lose. How do you factor that in? And have you had any experience of security for costs applications, which is another feature of the UPC, where a claimant can be asked to provide security for costs to cover the defendant's legal costs?
Yes, maybe I'll talk about the first part of it, and somebody else wants to talk about the bond or security. I mean, as a defendant, often you're really concerned about the injunction. You're concerned about damages. In the U.S., it could be treble damages. But coming back to the UPC, I'd say that the fees, and especially because they tend to be statutory fees, so at least it's not the fees that a lot of you folks charge in the law firms. It's not insignificant. It's something that we want to make sure our finance folks are prepared for, so they're not surprised. But that's usually not a major factor to us compared to everything else that's going on.
Yeah, and so similar comment, which is basically, it can be a relatively large amount, but it is essentially capped, right? It's essentially because there is, a kind of limit that is imposed by the court, and so it's not what the other side actually spends; it's some subset usually of that, right? And then with regard to potentially security and stuff like that, so the defendant in our cases did seek to force us to post a security, and the court actually didn't require us to do that. Their argument essentially was, we're a U.S. company, right? We're not a European company. So sort of those sorts of arguments, right? And it really kind of fell flat, essentially we're a big company, right? And we're there's no risk of us not being able to kind of, potentially pay if there was a situation where we were going to lose or something like that. And obviously we do have a relatively large operation in Europe as well. And so we didn't actually have to post security, but that doesn't mean that's always going to be the case.
Ari, any final thoughts on money, finance, all
that? In some ways, I'm not in the perfect position to comment on that. But what I would say about security for costs is that it is an odd regime to sort of start out with the assumption that a non-European company is somehow not going to pay their debts, and it's somewhat unrealistic. But I also think that in this first 2 years of the system, every single possible argument under the sun has been run in the UPC, and oftentimes they've been appealed as well. And so we've ended up with hundreds of little points in every single case. And as we go forward, perhaps the practice will stabilize so that people will understand when can you go for security for costs, which in my view should be when there's a real objective appearance. It starts to smell like, it smells like a case and looks like a case where actually the other side might run away and not pay their money. So in that kind of case, yes. But in other situations, the party should be less concerned with this, and the court should develop a practice to make sure that cases are more streamlined. Because the more we have of little, petty squabbling over security for costs at various stages of the case, the longer the case will ultimately take, and we won't hit that 12-month deadline. And so we've got to keep them streamlined and only raise the issue when really necessary.
One other point that I forgot to mention on the money point is basically there is the potential for damages, but the thing that's a little bit strange compared to the U.S. system is that case for damages usually follows the initial case on liability and the injunction. And so there hasn't been, I think, a whole lot of case law on that because of the fact that comes later, but there probably will be additional case law with regard to damages for these UPC cases. But for those that are used to European litigation already, national courts, I think that's quite similar to the way things work in the national courts. But it is a little bit strange for U.S. attorneys that at the end of the case, you don't really have that damages stuff. You have to have kind of another case just about damages.
All right. Well, we're getting the hook, so don't want to stand between you and lunch. So thank you very much.